What documents do you need to successfully and correctly complete a subject to deal? That's what we're talking about today on the Sub2 Deals Show. Hey, deed grabbers, welcome to this episode of the Sub2 Deals Show, where we talk about all things subject to. Occasionally, we do talk about other real estate investing topics, but it's always something to help you with your real estate investing business. You know, it's been a while since we talked about the actual documents that you should be using when you close a subject to deal. Now, let me start this by saying, if you go out on the interwebs or wherever it is that you like to get your information and you talk to 10 different teachers on the topic of subject to, they're probably going to give you 10 different answers as to what documents that you need. And that's okay. You know, there are teachers out there who, like me, didn't even finish high school. There are teachers out there who are attorneys and because of that, think they know everything about it. And there are people out there who have I guess, sort of a fast and loose approach to how to do it, and people that are very meticulous. All I can tell you about the documents we use is that over the last 26 years that we've been buying property subject to, the document list that we use has evolved as laws change, times change, expectations change. And the list that we are going to talk about today is somewhat different than the list we used just a couple of years ago. And for the most part, the key documents are always going to be the same. And you've probably heard me say this 1,000 times. You can buy a property subject to with a deed transfer. That's it. Bob's got a house he wants to sell. He deeds it to me. He walks away, hands me the payment book or changes the invoice or monthly statement address to me, and I'm making the payments. And that it really is pretty simple. It's kind of a stupid way to do it, really, when there's some protections you can put into place. That'll help things move along a little bit better. But I'm going to give you the list of the documents that we use today. And like I said, for the most part, they're the ones that we've used for the past 26 years with a few adjustments. So let's talk a little bit about them individually and why we use them. And we'll talk just a little bit about each document as we go along. Now, to make things simple, I like to talk about paperwork for a subject to deal in terms of stages. If I meet with a seller and we're agreeable on things, we're going to get what I call stage 1 documents. So that's the stuff that locks the deal up for me. It gets it under contract. I have control of it, and I can perform due diligence. Once the due diligence process has been completed, then we're going to move into stage 2, and what some people would say are actual closing documents. Now, you may close all of your sub-2 deals with an attorney, and pretty much every attorney out there is going to tell you you should. I've probably closed 95+% of all the hundreds of ones we've done with little more than a mobile notary in most cases. A lot of them these days we just do with the bank. The bank usually has a notary there. We can use their conference room. It's all very official looking. And I assure you, we own that house just as much as if an attorney had closed it. Now, we typically don't do that to save money. It's not the reason for it. We do it just for convenience purposes, and most sellers just don't care. Occasionally, you'll run into a seller that thinks a closing has to happen on a mahogany table inside an office where the walls are usually green and tan, but that's okay. If that's what they want, then you should do that too. But for the most part, we use a notary. It's just convenient. It's easy to do. And I got used to doing it when I was out of the country, so I preferred it. So let's talk about the actual documents. Now, when I've met with, let's just say Bob, because it's easy. When I've met with Bob and we're in agreement, he's okay with me taking over the payments on the loan on the property, deeding it to me so he can get on with his life. I'm going to pull a grouping of documents out of my buyer's briefcase that I carry with me all the time, and we're going to sign those. Now, what does that first stage 1 package look like? Well, number one, there's going to be a purchase and sale agreement. Okay. That is going to lay out all the terms that Bob and I agreed to about how I'm going to purchase this property. It's going to reference the fact that I am buying it subject to the existing financing. I'm going to reference the loan that I'm taking subject to, the loan number, the approximate principal balance at that moment, when I will start making payments. A lot of times sellers that aren't in distress will make a payment going out the door. The house we just bought a couple of weeks ago, the seller gave us the keys on the 24th of June, and he made July 1st payment. Now, we won't have a payment until August 1st, by which time our buyer will be inside the house, and that works out real well. The purchase and sale agreement will also have closing dates, due diligence dates, the amount of time that we have to do our due diligence, as well as the name of the seller, the name of the purchaser, and the standard stuff that's in most contracts. Now, as an investor, I typically use a couple of different purchase and sale agreements, depending on what my strategy is. If I'm buying subject to, I have a very specific subject to purchase and sale agreement. If I'm going to wholesale the deal or do something else, I have a different contract that's got some different language. And you should too. There should be different contracts for different things that you're going to do. Remember, a sales contract isn't anything special, but an ideal one will have let's just say advantageous things for you as the investor, or for you as the buyer or seller, depending on what position that you occupy in that transaction. I've seen some contracts that are very, very heavily slanted toward the investor. And I don't necessarily think that's a good idea. I think if there's ever any what shall we call it, disagreement about things that comes up in front of a judge, a heavily slanted contract is not going to look good on you. Now, I do like some things in my contract to be somewhat slanted toward me. For example, if I'm the purchaser in a transaction, my closing date is going to be on or about a certain date. Now, what does that do? That's going to give me a little flexibility. If I can't close on the specific date for some reason, it gives me some wiggle room. If I am the seller in a transaction, the contract that I provide says that we will close on or before the date in the contract. Now, what does that do? That doesn't give my buyer any wiggle room unless I want to give it to them. So for me, those are things that give me a slight advantage, and that's okay. But when you start talking about things in your contract, such as I saw a contract that actually said, and then this was a subject to contract, and it said that if the seller on this property ever did anything to cause a problem with the lender, to tip them off a subject to transaction has taken place, to cause a problem for the investor, and the investor had to deed the property back to the seller, not only would they deed the property back to the seller, but the seller also authorized a $50,000 lien to be recorded against that property in favor of the investor. So basically a penalty for being bad. Okay. Things like that, I just don't think they look good. And we don't have anything like that in our contract. You know, people are going to do what they're going to do, and there's not much you can do about it. Now, you can lay out some things in your contract to try to discourage it, but ultimately, you want things to go well. And I'm happy to say that almost all the time for us, things go okay. You know, if you treat people fairly, I think generally they'll treat you fairly too. So the first document we get in stage 1 is a purchase and sale agreement. Now, the next document we get is a borrower authorization to release information. And what is this document? This document just says Bob is giving William permission to talk to Bank of America, whoever their lender might be, about the loan in question. I can call and verify things about terms. I can ask about if there have been any loan modifications or forbearances. I can find out if the loan is current, find out what the rate is, how much the payment is, if the escrow is in good shape. I can ask any questions I want about that particular loan. And it's a really simple form. A lot more lenders now are demanding that you use their specific form. And so really, in most cases, it's the same form, just with the letterhead of the bank on top of it. Now, why they want their specific one, who knows? But a lot of them do now. So, and we will get the borrower authorization, but let me give you a tip here. The best thing for you to do is, when you're in agreement with Bob on buying his house, get all of your documents filled out, then pick up the phone right then and there while you're sitting at the kitchen table with Bob and call the lender. Bob can verbally give them permission to speak with you, and you can find out everything you want to know right then and there at the kitchen table. Keep that form. Go ahead and get it filled out, because you never know when you may need it in the future with another lender, because lenders do sell notes. And you may buy the house from Bob today with the servicer being Mr. Cooper, but then 60 days from now, it may be with Bank of America. You just never really know. So get the form, but make the call while you're sitting there at the kitchen table, or on a three-way call if this is a remote deal. The next form that we get is a seller property disclosure statement. Now, that's a pretty standard form. Anytime someone lists their property for sale, an agent will get a seller's disclosure statement. And that is just really a run through of all the systems and the things that the house includes, and plumbing, air conditioning, electrical, things like that. Are they in good working order? Yes or no. If they're not, if there's anything wrong, tell us about it. Are the ceiling fans working? Are the light fixtures working? It's about a 3-page form, and it's just yes, no, or not included, basically. So it's just really about the condition of the house. And you'd be surprised, but most sellers will be honest with you and tell you if the ceiling fan in the master bedroom doesn't work. Just working through that form, each one of those things, asking specifically about it. It's a helpful form. And for the most part, as I said, they're pretty honest. The next form that we get is the ultimate seller's disclosure. Now, this is a 3-page form that just gets the seller to attest to numerous things, including that they have reviewed your offer, they agree it's in their best interest to take it, that they're not under the influence of any drugs or alcohol, they're not under any kind of duress, we haven't threatened them in any way to make their decision, they've had the opportunity to speak to an attorney and chose not to, they're fine with moving forward with the transaction. There are about 30 items on this checklist that they have to initial and sign off on. It's pretty much everything under the sun. But I'm telling you, you'll find over time, it's amazing the number of people that can come back and say they didn't remember or they didn't know what they were doing. And this form pretty much takes away a lot of those options. Now, the last form that we may get during a stage 1 is a limited and specific power of attorney. Now, whether you'll get it or not will probably depend on a few factors. Number 1, are the people still living in the house? A lot of times, if people are in situations where it may be tough to catch up with them later, we'll go ahead and get that form, and we may even go ahead and get a deed right there on the spot in case they're tough to get a hold of in the future and we really want to close this deal. So the limited and specific power of attorney that we get is a durable, irrevocable limited and specific power of attorney. It only refers to this property. In other words, we can't have them committed. We can't control any other aspect of their lives, make medical decisions for them or anything like that. But it gives us the authority and the power to make payments on that property, to make improvements, to pay the taxes and insurance, or change the insurance if we feel like that's needed. It gives us the authority to do anything needed and necessary with that specific piece of real estate. So in the past, we had a revocable power of attorney, but a couple of years ago, we started using a durable, irrevocable power of attorney. So those 5 documents, sometimes just 4, will be part of the stage 1 documents that we get. Some investors also like to get an affidavit of agreement to real estate that they may record at the courthouse, which, there's a lot of discussion about this. A lot of new legislation regarding wholesalers has something to do with this because, and I'm not lumping all wholesalers in this category, but for example, wholesaler goes out, they get a property under contract, they record a memorandum of agreement, they can't find a buyer or they abandon the deal and they leave that recorded document there. That can create a problem for that seller down the road if they're trying to sell their property and they can't find that investor or who knows what happens. But if you record a memorandum of agreement and you abandon the deal, you need to go record a release, or at least be willing to sign that release for the seller if that comes up. Now, here's another tip for you. Recording a memorandum of agreement with just your signature is a cloud on title. It's not a lien. The title company can decide to insure around it or over it and go ahead and facilitate another sale to someone else if they want to. A much stronger position for you to be in is to record a memorandum of agreement with your signature and your seller's signature. Okay, now you're going to have a notary for your stage 1 stuff if you do that. But I'm telling you, when the seller has actually signed that and they're okay with you recording it, a much different scenario, much more powerful scenario. And we only use these if we have a strong suspicion that our seller may not be being 100% honest with us or may seek out other sources to sell their house out from under us after we've gotten it under contract. I can probably count on both hands the number of times that I've ever used a memorandum of agreement and still have fingers left. We don't do it very often, and it's only if we really think that this is going to have the potential to be a problematic situation. Now, some other things that you'll want to get from your seller at the time of your stage 1 documents, maybe a copy of any leases if they're a landlord and the house is leased, a copy of any HOA bylaws if they are in an HOA. Now, you guys know I hate HOAs, but these days, there are a lot of them out there and there's some really good deals in some HOA communities. And some of them, the HOA fee is very, very small. So we have made some exceptions lately. The closing package from when they bought their house, this is super helpful. It's all kind of stuff in there. A lot of times there's a survey, there's a copy of their title insurance, the policy that they got when they bought the house, insuring title on the house from them back 50 years or more, their insurance policy for their homeowners. A lot of sellers don't even remember who their insurance is with, especially if they've never had a claim. And then a copy of their most recent mortgage statement. All of those things are really, really super helpful. So just a quick recap. Stage 1 docs, purchase and sale agreement, borrower authorization to release information, seller property disclosure, the ultimate seller's disclosure, and possibly your limited specific power of attorney and a memorandum of agreement. Okay, so now we're going to move on to stage 2, and this is going to be after your due diligence process and when you have absolutely decided you're going to buy this house. You'll go to a closing. Now, you'll either go to a closing with an attorney or you'll do it with a mobile notary. In each situation, the documents we use are pretty much the same. Number 1 is the deed. Now, the deed may be different depending on what state you're in. If you're in California, it may be a grant deed. In most states that we operate, and probably you will operate, you're going to want to get a warranty deed. Now, a lot of people will say, just get a quitclaim deed, and you won't have to pay any transfer taxes or any other stuff like that. Listen, a lot of title companies don't like a quitclaim deed. Anytime we're getting a deed, we want to get the strongest deed possible. We want our sellers to warranty good title. So we're always going to get a warranty deed. Number 2, a state-specific tax document. Now, your state may not have tax documents. When I lived in Georgia, every deed that was filed had to also have a PT-61 tax document, and this was with the Department of Revenue. that documented for real estate transfer tax purposes any sale that happened. And certain situations, you didn't have to pay transfer taxes. And Georgia transfer taxes, man, they were so low anyway. I mean, they were just insanely low. But you had to file that document with your deed. Now, here in Arkansas, there's no tax document that has to be filed. You'll either state the amount that you paid for the house, or you will attest to the fact that no transfer taxes due, one of the two, but there's no document to be filed. The next document that we'll use is a seller due on sale disclosure. And this document's pretty simple, and it just states that the seller is selling the property located at what address and has an existing loan that's going to stay in place with their lender, and we'll also reference a loan number and an approximate principal balance. And it also states that the seller knows that there is possibility of a due on sale event somewhere down the road. They understand they're proceeding with the transaction in light of those risks, and that they will hold us harmless if anything comes up regarding that. So that's important. Then we have something that I think is unique to us. Now, I seem to have heard recently somebody else is using this now, but we created this document probably 20 years ago. About 20 years ago, the Attorney General in North Carolina got on the warpath about Sub2 deals, and everybody thought, oh my gosh, this may be the end of it. What are we going to do? But this Attorney General's biggest complaint was that if a seller sells to you, subject to, and you fail to perform, that a lot of times seller has no recourse. So we created a document we call the seller recourse document. And it really maps out the steps the seller would need to take if we fail to make timely payments. It gives them a process to follow, and how they can get title back to the house, or what we would do to fix the issue. So we have that document. It's a one-pager. It's very simple, very straightforward, and we have our sellers, and we sign that as well. Next is a tax and insurance escrow acknowledgement. Now, 99% of the houses you buy with institutional financing are going to come with an escrow account. At least most of the ones that I've ever bought did. In the past, unless you put 20% or more down, lenders required you to have an escrow account. Now, that may have changed since then, but most people, I don't think, put 20% down these days. But the escrow account collects money every month along with your payment for taxes and insurance. And then they pay those as they become due. When you buy property subject to, you are also purchasing, along with that house and that loan, the escrow account, the shortage or the overage, whatever it may be. And this document acknowledges, the seller acknowledges that if there's a surplus there, that you are entitled to it. If there's a shortage, you'll be the one making that up. So we get a tax and insurance escrow acknowledgement. Okay, the next thing we get is a bill of sale. Anytime a house is sold, usually it comes with some things that aren't necessarily attachments to the house. It may come with an outside storage building. It may come with a stove and refrigerator, water purification system, solar, any other thing that's not actually a part of the house. And on this bill of sale, we list those items, and the seller signs that, because that becomes our property as well. A recent addition here in the last year that we've added to our closing package is an affidavit of solvency. I've always taught my students in the past to question the seller about if they had filed bankruptcy, because, of course, if they had, and they were in bankruptcy, you can't buy the house without the trustee's approval. But secondly, you don't want to have a seller sell you the house, file bankruptcy in the next few months, and then create a problem for you. Now, we've had sellers do that in the past, and usually a telephone conversation with their bankruptcy attorney or the bankruptcy trustee, us providing a HUD, a deed, and explaining the situation took care of the problem. But the issue is, let's just say, for example, that you get a really, really good deal. Let's say that Bob sells you a house worth $300,000. For the loan balance of $200,000, he wants $10,000 in cash, and he's out. Whatever his situation is. It's a smoking deal. You jump all over it. You've got your buyer in place, you've collected a down payment from them, and 3 months later, you get a call from a bankruptcy trustee, and he says, hey, Bob filed bankruptcy, and we see that you bought his house 3 months ago. Now, part of the bankruptcy court's authority lets them claw back a transaction where they feel like fraudulent activity happened, or there is equity that they can get their hands on to satisfy creditors. Now, you bought a house with basically $90,000 in equity, and chances are the bankruptcy trustee is going to want to reel that back in to pay Bob's creditors. The bankruptcy trustee can unwind your transaction. They can take that house. You talk about an angry buyer, that person that you've put in. Now you're going to be out your $10,000 to Bob. You're going to have to give your buyer their money back and still hope they don't sue you. This document, the affidavit of solvency, basically says that Bob is not in financial straits. He has not filed bankruptcy. He has no intention of filing bankruptcy for at least the next 12 months. Now, can Bob still file bankruptcy 90 days after he signs this? You bet he can. But we use that as just another tool that if we ever get that call from the trustee, we can say, look, Bob told me that he was not under any financial hardship. He told me that he had no intention of filing bankruptcy, that he was paying his creditors, and that he had plenty of money to do that. And we bought this house in good faith. So that's just going to be part of my argument, that affidavit of solvency. Now, will it work? You know, a lot of things sound really good until you use them. I hope I never have to use it, but if I ever do, it'll be there, and it'll at least be another point on my side to help me with not getting that asset taken back from me. The next thing we get is a seller's affidavit. Now, that's simply pretty much any seller that sells a house these days gets that document slid in front of them. And this just says they haven't had any work done to the house in the last 6 months that hasn't been paid for. So I have a reasonable expectation of no mechanics liens being filed or no other problems like that. Then we get an authorization for loan portal access. Now listen, you have to be very careful in some of the things that you're going to be doing in a subject to transaction. One of those is logging in under somebody else's name onto a portal to make payments, to check on escrow, to change insurance, to see what your principal balance is or anything like that. You're logging in, and you hear a lot of stuff. I've heard people say, if that's a federal institution, what you're doing could be called bank fraud or anything else. Now, I don't know if that's true or not, but I at least am going to try again to cover all my bases. So this authorization for loan portal access says that Bob is giving me permission to log into his lender portal. He's providing the username and password for me. I can change that if I feel like I need to keep things secure. And any future lender that the loan gets sold to, I also have his permission to log into that portal as well. So we get that document. The next thing we get is a HUD or an ALTA closing statement. You can write those up yourself. There are plenty of fill-in-the-blank forms out on the internet, PDFs that you can use to create your own. They're a pretty simple document, especially when you're buying subject to. Every person that sells or buys a house in the U.S. at any attorney's office or closing title company table gets a HUD or ALTA. And regardless of how you close, whether it's in an attorney's office or a kitchen table closing, you should make sure there's one there too. That is the ultimate sign that a sale has taken place. And you want to make sure that your seller gets one of those documents. And the last thing we get, in the past, we used to get a written testimonial from our sellers. These days, everything's social media and everybody's carrying around a high-tech video camera with them. We get a video testimonial from our sellers. It's very helpful for credibility purposes. It also would potentially help you down the road if your seller came back and said they didn't understand what they were doing. They didn't know they were selling their house. but we get a video testimonial. We always try to do it in front of the property, and we use that on our investor website as something to, as I said, give credibility, let potential sellers, we show them all of our video testimonials and our happy sellers. So stage 2 documents, we'll run through those one more time. That's going to be a deed specific to your state, a state tax document if your state uses them, seller due on sale disclosure, a seller recourse document, tax and insurance escrow agreement, a bill of sale, an affidavit of solvency, a seller's affidavit, authorization for loan portal access, a HUD or ALTA closing statement, whichever is appropriate where you live, and then a written testimonial and a video testimonial from your seller. So guys, I hope this helps. These are the things that we use in our business each and every day. No additional forms. This is everything that we do. And I feel very confident that if you use this closing package, that you'll be just fine. Now, like I said, you can provide this to your attorney. They may have a couple of additional documents that they require according to the state. We see those from time to time, but you can also use these with a mobile notary or at a bank if you know what you're doing. I don't advise for everybody to go out there and do that. We do it because we've been doing this for a really long time and we know what to do. If you're unsure, if you're asking yourself a question, should I use an attorney to do this? You probably should. Now, if you'd like to get a copy of all of these forms, as well as video instructions on how to fill them out, there'll be a link below where you can go and pick up our Contract to Close course. I recorded that a while back, and it's been really helpful to a lot of people. And I'm going to give you a tip on the Contract to Close course. If you would like to get the Contract to Close course at 1/3 of its regular price, go pick up my book, and you can do that at 12houseblueprintbook.com. And there'll be an offer inside of that page where you can get the Contract to Close course for only $97. I'm telling you, a comprehensive course, every document that you need that we just talked about, a bunch of bonus documents and videos explaining how to fill every one of them out. Again, this book, the 12-House Blueprint, is the exact plan that Jody and I use building our real estate business, and it's the only thing we've done for the last 15 years. So go check that out. Hope this helps. Hope you guys are having a fantastic week. Get out there, talk to some sellers, buy some houses.